Cecilio? Thank you. You may proceed.
Thank you, Your Honors. Good morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth. With me is the motion prosecutor, Assistant District Attorney, Donald LaRoche. I ask you to reverse an order from the Dorchester Division of the Boston Municipal Court allowing the defendant's motion to suppress. The defendant had not been seized by the officers who continued to follow him until after he had discarded the gun, at which point he had no privacy interest left in that gun.
Well, doesn't that depend on whether he was being chased and whether he knew he was being chased?
It depends on whether the police, he would know he would have to submit to the authority of the police. And as this court,
go ahead.
Oh, sorry. As this court has determined, whether someone knows that they have to submit or stop to the authority or questioning of the police depends on whether the police have had sirens, have activated their sirens, their lights, have somehow commanded or said stop, halt, or another command, or have somehow blocked or impeded the path, direction, or speed of the defendant. And here, the police did not exhibit any behaviors of show of authority.
Well, the court seems to suggest, and again, the findings are not so detailed that we can figure all of it out, but the court seemed to suggest in its selection of the words that after the defendant crashed into the tree with his bicycle, he got up and then took off, and the police got out of the cruiser and chased him. I mean, and that he was aware, at least as I read the findings, he was aware that he was being pursued by the police.
Correct, Your Honor. The motion judge did use the word chase, but I think it was the defendant running fast? Yes. Were the police running fast after him? Yes. But as stated in Commonwealth v. Perry, the appeals court said merely running after a person who is running is not a seizure.
Well, if he knows he's being pursued, I mean, the only question becomes whether or not there was reasonable suspicion to pursue, and in pursuit then seize him. I mean, if the pursuit is seizure, if I'm pursuing you, I've asked you to stop, I want to talk to you, and you leave and take off, and I pursue you, I think our case law is pretty clear that that's a seizure.
Correct, but here there was nothing. You said that the police have exhibited that they want him to stop. And
well, they asked him to stop, didn't they?
No, they asked him to speak.
Yeah, well, he was riding his bike, and they came alongside him and said, "We want to talk to you," or something to that effect.
Correct, but this
was he going to just talk on the bicycle as they rode along? Isn't that a request that he stop? I'm not saying that's the seizure. I mean, the police have every right to ask him some questions, and he has every right not to answer and to leave at that point.
That's correct, but that's not a stop. And merely asking someone a question, and then
I understand. But it's a request for them to stop and talk. I'm not saying it's a seizure, but it's a request for them to talk.
But that does not mean that the officers then following him afterwards, a defendant ignoring the police wanting to continue to follow him or talk, constitutes a seizure.
Certainly the police can keep him under observation, I suppose, but I didn't get the sense that that's what happened here. No. What happened was when he said he didn't want to talk to him or basically refused to stop, and then he took off, that the police got out of the cruiser and chased him, which is very different than just following around and seeing what he's doing.
Well, I think it was pretty much it was a reaction to what the defendant did. I mean, the defendant sped along, and he turned right onto Hancock Street, still in the view of the police officers, and the defendant hit a tree. He jumped off his bike, discarded his bike, and then bolted the other way. The police officers in their cruiser, I would say, responded in trying to follow him in the most practical means and got out of their cruiser to continue to follow him. I don't think that the mere act of them getting out of their cruiser to a mobile, agile defendant in this circumstance that raised their suspicions.
Well, they were chasing, two police officers were chasing him, and then a third was positioned down the block and then grabbed him when he came out of the bushes or something.
Detective Gallarelli was seated was standing at Columbia Road and Bird Street and was there not, it was actually inadvertent to the other police officers. And that was the seizure, but at that point the defendant had discarded his firearm.
May I ask you this? It seems to me that the judge actually concluded that when they were in the car following him and he increased his speed on the bicycle, that was when the seizure occurs, not when they got out of the car. But what the judge said in his findings was, as the officers got closer to the defendant, they asked if they could speak with him, and the defendant sped up. The officers correspondingly sped up. At that moment, the officers violated the defendant's constitutional rights, and their pursuit constituted a seizure. So the judge concluded that the seizure occurred when they increased the speed of their car.
Increase, and I contest that. That was error.
Long before they got out of the vehicle. Was that error?
That was clearly error. I think that just because the defendant ignored the request to speak and then the police decided to keep pace with him and follow him, that did not constitute a seizure. I mean, Commonwealth versus Grandison, this court held a defendant who clearly showed he had not wanted to have anything to do with the police, that the police making U-turns with the defendant and following him into an alley where they turned on their alley lights did not constitute a seizure.
But we can affirm on another ground. And, of course, if in fact he was seized once the police gave chase, then we have to determine whether there was reasonable suspicion at that time.
That you could find that judges...
And if we found there was no reasonable suspicion at the time of what we view to be the seizure, then we can affirm on that ground.
Correct. I mean, I'm not giving up that the defendant was seized until he discarded his firearm. But if you were to place the moment of seizure when the police got out of their car and started to follow the defendant, at that time I would say that they definitely had a reasonable suspicion to seize him at that point.
And what was the reasonable suspicion?
Based on what?
The officers had come up to Bird Street and saw the group of 10 to 20 individuals. The defendant was part of that, looked at the police, and started to pedal his bike away from the group. This was also in a high-crime area. And while he was pedaling away, I think it was key that he kept looking back at the police officers. The police officers then decided to ask him if they could speak to him. The defendant ignored him, correspondingly sped up. And at that point, he turned right. He hit a tree. He discarded his bike and did a U-turn and started running the other way. And while he was running, he was clenching his waist. I think, the defendant clearly hitting a tree and
What does hitting a tree have to do with? Why is that suspicious activity?
Because it would in hitting a tree, it was not what I would say that he first would want to separate himself from the bike, and at that point you could say that maybe he had stolen the bike and he didn't want to have anything to do with the bike, and you got to get off and run the other way. But I think that
so it's not hitting the tree; it's discarding the bike.
Yeah, it's separating himself from that bike and doing all he can then to run down the street in the same street he had originally come.
Why doesn't Tebow cover this situation?
Tebow involved the fact where the police were following the defendant, going after the defendant, pursuing the defendant with their sirens on. And this court has clearly said that going after a defendant who is on a bike, I think it was in Tebow, is a seizure. I mean, here we had no sirens, we had no lights.
No, but Tebow, the point I was looking at is to whether or not what the suspicious activity was. And Tebow was a bicycle and took a sudden turn off in a different direction. I didn't crash into a tree, that's for sure, but... I mean, respectfully, Your Honor, we had much more than Tebow. We had the defendant breaking away from a group in a high-crime area, looking back at the officers. This court has taken that into consideration in reasonable suspicion analysis.
It was an unmarked car, was it not?
Yeah, correct, in Crown Victoria. But, I mean, upon the defendant looking at the police and then taking off from the group and looking back at them.
How would the defendant know this was police?
Crown Victoria is a known police car in the area, but just
his civilians don't buy Crown Victorias?
What?
Civilians don't buy Crown Victorias?
It seems civilians do, but police often drive them around. But I just think the defendant's reaction to the police as they came would think it's not just any person, group of people riding up.
A thug. It's a thug is running after me. I got to get out of here.
Well, it was, I mean, clearly by the time that defendant's looking back and the police have pulled next to him
You
and
must
asked
see
him
how
to stop.
close the thugs are behind him.
Well, he could, but then when the officers pulled up and asked them if he would speak, I mean, at that point, they had shirts and their badges were shown, and it said Boston Police Anti-Crime Unit. And then the defendant then jumps off the bike. I mean, if we get to the bike part, he discards the bike and runs the other way, and he's clenching his waist.
Now, you read something into the fact that he was holding his pants up?
I mean, I think through the eyes of a trained and experienced officer, I mean, this court has held that movements to the waist are quite evident through the eyes of an officer that he could be carrying a weapon. I would think then his movements trying to get away from the police would show he was illegally possessing
Well,
that weapon.
again, the judge found that the clenching of his waist, that behavior is consistent with concealing an object. It is also consistent with non-suspicious behavior, such as keeping on one's pants. We see young people walking around all the time nowadays with their pants about to fall off.
No, that's true, but
Can't run very well with your pants.
no, but I would. But this court has also acknowledged the fact that innocent activities that have been
So let's see. We have a group of people who are not engaged in any criminal conduct, correct?
That's correct, Your Honor.
And somebody decides to leave
That's correct, Your Honor.
and gets on a bicycle.
Yeah, that's
Gets
correct.
on a bicycle, perfectly innocent behavior, and sees a car which has no police markings, no blue light, no badge, no nothing. Correct?
The police officers were wearing badges on their necks.
And there was
Inside the
evidence
car.
that the defendant could see the badges from where he was going away?
Well, I think at the time that they pulled alongside him, and
No, I'm just talking about when he gets on the bicycle.
there's nothing in the judge's findings on that point.
Okay, so we've got absolutely nothing up until this point. Agree?
No, I would disagree. I mean, I think that based on the rest of the group of individuals stayed there, and the defendants.
Now, wait a minute. So when I leave a group of people and get on my bicycle and pedal away,
And look back at the police officers. I
but
think
I don't know. I don't know it's a police officer. I look back. Maybe I'm looking back to wave at my friends.
I would say taking those into consideration, and then what followed afterwards.
Well, no, wait a minute. We're just going step by step.
Okay.
So, but you're saying that there was suspicious activity at that point?
I think that looking through the eyes of a trained and experienced officer, that he could think that the defendant was up to something. I mean, the defendant, what the officers did at that point, though, was just merely following them and did not in a way infringe on his constitutional rights. I think that when they pulled
Just
up
tell
to
me
him,
what it is about the conduct up until that point that makes somebody think that they're engaged in suspicious activity.
well, I think that what the officers saw may or may not have given rise to a suspicious activity, but that what they did, they don't need to follow someone with any sort of suspicion.
That's correct.
And so what then escalated after that gave them more suspicion. The defendant, separating himself from that bike and clutching his waist.
That's different. So I'm trying to get step by step. Nothing suspicious up until that stage. They pull alongside him. He's on a bicycle. They're in a car. Mm-hmm. And they lean out the window.
Yes, correct. And they say, "Can we talk to you?"
And he pays no attention to that.
Correct. And he pedals ahead, and the police kept following him. They did not turn on their sirens. They didn't tell him to stop.
No, that's right. So up until that stage, it seems to me that Tebow absolutely covers. Nothing suspicious up until that point, correct?
No, well, I don't. In terms of Tebow,
Looking at whether the activity is suspicious.
I would say that looking through the officer's eyes, that activity could have was suspicious.
But
I don't think
we said it wasn't.
What?
We said it wasn't.
But in Tebow, it was the suspicion was that lots of people commit crimes on bikes, and so then that's
we
why.
were looking at what the conduct was, and we said that wasn't suspicious.
In Tebow, because it was someone that was riding a bike, and you said riding a bike isn't suspicious. Where here we had a defendant breaking from a group, looking back at the officers, then ignoring the officer's request. But what the officers were doing was following the defendant, not infringing on his constitutional rights.
No, I'm not asking whether or not they were doing anything wrong. I'm simply asking whether there was anything suspicious up until that point.
I think that through the eyes of the officer, I think it could have been seen as suspicious.
But it doesn't matter, does it,
No.
if they're just following?
No, that is correct, and that's what I was saying, that, pulling alongside him, asking a question, and then just continuing to follow him did not implicate his constitutional rights. The defendant was free to do whatever he wanted, and he was able to turn right, hit a tree, and run back the other way. And the police correspondingly tried to keep following him and needed to get out of the car to do that. And my time is up. I just ask you to reverse the allowance of the motion to suppress. Thank you.
Thank you,
Your
Ms. Celia. Ms. O'Reilly?
Good morning, Your Honors. May it please the Court. My name is Ann O'Reilly, and I represent the defendant, Dwayne Sykes. This Court has said recently in Commonwealth v. Barrows that determining the precise moment of seizure is critical to the resolution on the issue of suppression.
You cite the case of De Silva for support that the police activity here was a stop, but in De Silva, the police were following the defendant and ordered him to stop twice, and that there's no equivalent here. The police never ordered the defendant to stop here, not even once.
They did not order him to stop. They asked him if they could ask him some questions.
And that's perfectly permissible.
Perfectly permissible. And
Did they identify themselves as police officers?
they did not. There's no evidence in the record that they.
Well, I thought she said they had their badges on.
They had.
They had
They
badges.
had badges on. The judge found that they did have their badges on. They were in an unmarked vehicle, and they did not have. I think they had T-shirts that said, something to the effect of drug control, drug crime unit, or something.
What
like
time
that.
of day? What time of day was this?
It was 6 o'clock. It was August, so it would still be light
Light.
out on an August day at 6 p.m.
And where was the bicycle?
It didn't say. The judge didn't find that.
I'm talking about when the
I'm-
defendant was pedaling along.
I'm sorry.
When the defendant was pedaling along,
where was the bicycle?
was it on a road? Was it on a highway? Was it on a
It was
sidewalk? Was it on a...
He was with the group at the corner of Bird Street. He got on the bicycle and pedaled away down, I believe it was Bird Street.
On a sidewalk or on the
I believe it was on the street. There was no indication that it was on a sidewalk.
And what is Bird Street? Is there anything in the record as to what type of a street Bird Street? Is it a narrow street? Is it a
There is nothing
divided road?
There is nothing in the record that indicates that it was a narrow street or wide street. There's nothing in the judge's
I
findings
take it that the
concerning that.
seizure is when the officer steps in front of him, correct?
I'm sorry?
I take it that the seizure, at least according to the judge, is when the officer steps in front, the officer anticipating which way the defendant is going to go?
The Commonwealth claims that that's when the seizure occurred. And if under the Fourth Amendment, under Hodari D, that would be when the seizure occurred because there was a physical taking. However, in Massachusetts, under Article 14, we have much greater protections concerning seizures. And
Well, even if you don't find just the officer stepping in front of, and your point is the seizure occurred when?
I agree with the judge's findings that the seizure occurred at the moment the defendant was on his bicycle. The officers asked, can we speak with you? Or can
How
you
can that be a
answer
seizure? I mean,
I'm
our
sorry.
cases have held that that isn't a seizure. Just asking if
That
we can
alone
speak
is
with
not a seizure. Under Massachusetts law, he has a perfect. Police have a perfect right to ask anybody any question. The moment of seizure occurred, not quite yet. The defendant sped up on his bicycle. Seizure hadn't occurred yet. Seizure occurred exactly when the officers sped up after him.
Why? You can follow somebody in a car, in an unmarked car. They hadn't
Yes.
announced that they were police.
You can follow somebody in an unmarked car. However, the judge found that once the defendant, in essence, said by speeding up, "No, I don't want to answer your question," and the officer sped up after him, it was infused with police authority.
What was the authority?
The authority was basically he did not want to speak with the police.
They're perfect strangers. They haven't said that they're police officers, and there was no indication in the record that they had presented themselves as police officers or that he understood that they were police officers.
There's no indication in the record. We don't have the transcript to know exactly what the defendant was thinking at the time, but in terms of what the judge found that the seizure occurred.
What was the basis for the judge's finding there was any official show of authority?
Because, in essence, the defendant was saying, no, that he didn't want to speak, and he sped up in response.
But what was the evidence upon which the judge could have concluded that there was a show of authority, that there was some official presence there?
Well, because the judge characterized what followed as a pursuit.
Pursuit by whom?
The judge characterized it as a chase, which is, in essence, is a pursuit by the police of the defendant.
But there's no evidence that the police had told the defendant that they were police, either implicitly or expressly.
It's not in the judge's findings.
Well,
but I think-
wait a minute. Now, didn't you say, or wasn't I told they had on their badges
They
and
had on their
shirts?
badges, and as-
And so when they asked if they could speak with him, I assume they were close enough so that he could hear them ask that.
Yes.
So can we assume that he then saw their badges and their shirts?
We could assume that.
So he was on notice they were police in this Crown Victoria.
Yes.
Were these police jerseys? Did they have like the shoulder
tactical
patches?
police force. The rec finding says they had shirts on with Boston Tactical Police
Yes.
Force emblazoned,
Yes.
or
on there.
Boston Anti-Crime Unit emblazoned over them.
And badges. And as Nasilio said, that, in an unmarked Crown Victoria, but, it's possibly known that
Well,
that's
the
an unmarked
Commonwealth,
police
for
vehicle.
that purpose, wants to have it both ways, to say
Excuse me?
the Commonwealth, for that limited
Yes.
fact, wants to have it both ways. He must have known they were police officers because they were in a Crown Victoria.
Yes.
Therefore, but they didn't know that it was a police officer.
Yes. I would argue that this court, that this case is completely decided by Thibault, because he was on a bicycle, and there were no factors which would enter into any reasonable suspicion analysis.
But I mean,
you
he's
saying-
right. He's right. He's speeding away from a police cruiser. He has every right to do that. He hits a tree, discards the bike, and takes off holding his waist. I mean, why isn't
He
that
might-
enough? Reasonable suspicion.
He could have been.
But is your position that the seizure occurred before that? Or what is your position precisely when the seizure occurred?
I agree with the judge that the seizure occurred at the moment that the officer sped up after him. However, if the seizure occurred, assuming arguendo, I guess you could still find that the seizure occurred once the defendant was, off his bicycle. But the thing is, clenching his waist, he might have been hurt. And the judge found that clenching of the waist is not sufficient.
But
it's not like he was drawing. He didn't appear to be drawing a gun, or that it wasn't. It didn't put the officers in fear. And also, there were 4 officers, and actually 5 at this point, because another detective had joined them. So there were 4 officers
In the car?
When the defendant hit the tree and discarded his bike, the officers got out of the vehicle.
But
and,
we have to
started
look
chasing him.
to see whether there was probable cause or reasonable suspicion at the moment the seizure occurred.
At the moment the seizure occurred, of course, and anything that anything that and under Thibault, which this court, is still good law in this court, that anything that happens after the seizure cannot be used in the reasonable suspicion analysis.
Aren't the facts different in this case in Thibault?
Not-
Did the police have on sirens, blue lights? Did they do anything in an overt way to...
Well, they didn't have on their blue lights or sirens. In Thibault, it was 10 p.m., so that was another factor. It was also a high-crime neighborhood in Thibault. Here it was 6 p.m. So, in Thibault, there were two cars and sirens. Here, there were no sirens. There were no blue lights, but they were speeding up in response to the defendant speeding up, which I think under these circumstances is a factor, because they had asked him if he would answer some questions, and he, in essence, said no.
Why isn't this simply putting a tail on somebody?
Because it's considered a chase, which changes the psychological, it's basically a coercion.
But what makes it a chase? They hadn't said stop and come back.
Because the object, under Lefebvre, the object of a chase is capture. And with surveillance, the object of surveillance is observation. And so once...
So it's okay to follow someone, but you can't chase them.
And if they go fast, how do you follow them?
Well, then you're chasing them. You know, if the defendant was just, leisurely bicycling, then, and the police just kept on at the same pace, then possibly the seizure might not have occurred at that point. But once they sped up, they were showing their authority, and they were basically saying, you must speak with us. And this court has said that is not under Article 14. That's not allowable for police.
So it has to be a pursuit, as I read the language, a pursuit that indicates to the suspect that he is not free to leave without responding to the police inquiry is a seizure.
Yes, exactly. And
you're saying the speeding up of the police car in this instance was such a pursuit which would have indicated to the suspect that he was not free to leave without responding to the inquiry.
It was absolutely communicating that he wasn't free to leave because he tried to leave and they wouldn't let him, which is why...
But they did let him.
Well,
he stopped himself. He ran into a tree.
Well,
in other words, you know.
I don't think they did let him. If they had allowed him not to speak, they wouldn't have sped up after him. And as soon as he hit the tree, they got out and on foot and chase him and continue chasing him until they capture him. And so that's why I would argue that the seizure occurred at the moment that the officers sped up after him. And at that point, there were no factors in the reasonable suspicion analysis other than that it was a high crime neighborhood. Because under Tebow, he was on his bike. Any kind of suspicious, veering away cannot factor into that reasonable suspicion analysis. It can factor in, but it's not sufficient for reasonable suspicion. And officers had to have reasonable suspicion at the moment of seizure under Article 14. So I would argue that there was no error in the judge's findings or in his conclusions of law.
Thank you, Ms. O'Reilly.
Okay, thank you.